Hello students, in our last lecture we discussed up to the topic number 13. Now today we discuss on a condition of contract, point number 14, breach of contract. So in case of the contractor failed to carry out the work with contractual obligation, so the owner must have to right to claim the damages for a breach of contract. So however, such damages will not always be an adequate remedy, and provision must be made in order to get the work complete. So in this case of abandonment of the work, owning and bankruptcy or liquidation or serious illness or death of the contractor or any another cases or any another causes, the owner shall have a power to adopt any of the following courses as he may deem best suited to his interest. And here two cases is there. First one is to resign the contract, and the second is to take over and complete the work as an agent of the contractor. Now the owner shall have to right to employ labor and supply material to carry out the work or any part of their work with the cost of labor and the price of the material, and crediting him the value of the work done at the same rate as if it had been carried out by the contractor under the terms of the contractor. So the owner shall also have the right to take a position of and use of or a permit to use are all the tools, plant, material, machinery, stores provided by the contractor for the execution of the work, and paying or allowing for the same in account of the contract rate or at the current market rate. So contractor shall not remove tool, plant, machinery, etc. from the site without written permission of the owner, and the engineer in charge shall determine the cost of all the work done by the owner acting as an agent for the contractor, and in that case the certificate of the engineer in charge shall be final and conclusive against the contractor. Now another condition of the contract is a 15 number is a labor law. So it is the agreed by the contractor that he shall have to respect the provision of all the labor law which are in force from time to time, and contractors shall be responsible for all the claims, compensation, etc. occurring under the provisions such of the labor law, and contractor shall not employ coal mining or control area labor falling under any category or in a connection with the work. So no labor should be imported from any district other than where work are to be when the work are to be executed without prior consent of the engineer in charge, and no labor under the age of the 15 years shall be employed on the work. So the contractor shall obtain valid license under the Contract Labor Act before commencement of the work, and shall continue till the completion of the work. So the minimum wages and amenities of the labor shall be maintained according to the provision of the Labor and Wages Act. Now 16 number of the condition of the contract is a settlement of the account and settlement of the account or a final payment. So after acceptance of the work under this contract, the engineer in charge shall prepare a final estimate of the work within the 1 month from the date of such acceptance, and issue a certificate for a final payment to the contractor. So no such a certificate shall be given by the engineer in charge, nor shall the work be considered to be completed until the contractor shall have removed all his rubbish, tools, plant, scaffolding, material, etc. from the site. Upon submission of the final statement by the contractor, so the contractor is expected given to the employer written discharge starting that the final payment shall release the owner from all the claims and liability to the contractor in performance of the contract. So the owner, after receipt of such a certificate from the contractor, shall pay the entire sum within 1 month after deducting all the previous payment, other due, etc. And one half of the retained amount shall be paid along with the final payment, while uh, other one half be paid at the end of the maintenance period. Now 17 number of the condition of the contract is a public travel. So the contractor shall obtain written consent of the engineer in charge in case of the public traffic is to be obstructed for the proper execution of the work under this contract. In all such a cases, the contractor shall put at a suitable place, plain and properly worded sign and red lamps at night to indicate the obstruction, and to inform the public regarding the shortest and easiest route. So the contractor shall keep the owner free from all the claim, damages, losses, etc. arising out arising out or in relation of the such a matter. Now next 18 number condition of the contract is a clerk of works. So when the construction of the project is large, it becomes necessary to make a provision of the clerk of work who is qualified person approved by the engineer or architect, and who is appointed and paid by the owner. So the clerk or works inspect and supervise the work on behalf of the architect, and the contractor is supposed to give him full cooperation and assist to perform his duty well. So the clerk of the work shall be qualified, competent person to satisfaction of the architect or engineer, and he shall be appointed and paid regularly by the owner as per recommendation of architect. So the contractor shall afford every facility and assistance to the clerk of the work for inspecting and work and material, and for checking and measuring time and material. However, subject to these clauses, contractor shall take instruction only from the engineer or architect. Now 19 number Now 19 number of the condition of the contract is a compensation in case of the bad work. So if the work is found to have been executed by the contractor with unsound, imperfect or unskillful workmanship, or with inferior material or a bad material, or it is not according with the contract, so the contractor shall make good the defect in the work at his own expenses and remove the material or articles complained in a writing by the engineer in charge. So if the contractor failed to do within the period as specified by the engineer in charge, so the contractor shall to be liable to pay compensation at the rate of 1% per day up to maximum of a 10% amount of the estimation. So if the contractor failed to rectify the defect or remove or replace the defective material, the same may be done at risk and cost of the contractor. So it is all the responsibility of the contractor to complete the work and clear the bed work from the site. And 20 number condition of the contract is a maintenance period. So the contractor shall be liable for any damage done or any defect noticed within the prescribed maintenance period of 3 months, 6 months in case of the road work, and 3 months in a building construction. So the work shall be as soon as practicable after the expiration of a maintenance period be hand over to the engineer in charge in a good and perfect condition. If any damage, defect or imperfection become apparent in it from the agreed date of commencement until the end of the maintenance period, so the contractor shall make a good same at his own expenses, or in a difficult the engineer in charge shall be entitled to carry out such a work by the other workman and deduct the expense from any sum that be due to contractor or from his security deposit. Now 21 number condition of the contract is a supervision by the higher officer. So at the work under the contract shall be executed under the direction and subject to the approval in all respect of the engineer in charge or the SC of the circle for the time being, who shall be entitled to direct at the point and in what manner the work are to be commenced and carry out. Now 22 number condition of the contract is suspension of the work, sorry, supervision of the work. If at any time engineer in charge shall be any reason whatsoever required that whole or any part of the work to be suspended for any period, he shall give a notice in a written or a writing ordering such as a supervision work of the contract, and who shall thereupon suspended or stop the work totally or partially in any faulted case. So the contractor shall be entitled to the reason compensation for any resultant unavoidable expenses to him on account of suspension of the work, and he shall also be entitled to reasonable extent of a time to complete the work. And last is arbitration. In a condition of the contract, last is arbitration. So arbitration is required at the time when both the parties are dispute with each other due to some of the technical problem or due to amount problem or any another dispute is there. So at the time arbitrator is compulsory required. So arbitrator solve the dispute between the two parties and complete the work and solve the problem and ask to complete the work within in a time limit. So here we stop our lecture, and in next lecture we discuss in another topic. Thank you.